about the Grammys, and I want to reflect on my friend Warren Zevon's Grammy in 2003 for the song "Disorder in the House." To the land of the home of the free and the land of the brave, where the less you know, the better off you'll be. With that homage, I go on to my statement. This bill, H.R. 3808, has nothing to do with expanding infrastructure or bolstering our economy. It has nothing to do with people on scaffolds taking higher risks so they can get better judgments from a court and risking their lives 50 stories above the ground. That's ludicrous. Hold that up, please. These people, men and women that get up on scaffolds, don't do daring stunts to get money through trial lawyers. That is baloney. This is aimed at overturning the absolute or strict liability regime of the state of New York's labor law, known as the scaffold law. Under that statute, contractors and owners on construction projects have an absolute duty to provide safe scaffolding, ladders, hoists, or other elevation equipment. It prohibits any absolute liability lawsuit, this bill does, based on a claim for injury stemming from the failure to provide such equipment for any project that directly or indirectly receives federal financial assistance. That's ludicrous. Would you want to get up there? Would this be a safe place to work? Wouldn't you want the best rules and the best laws and the best sureties that you could have to say that you wouldn't lose your life and your family wouldn't lose their breadwinner? I think you would, and New York does too. New York courts have interpreted the scaffold law to impose absolute liability, but only when a contractor owner has failed to provide proper and safe equipment, and that failure was the proximate cause of the worker's injury. That makes sense. That's family values. The ultimate goal of imposing such modified absolute liability on contractors and owners is to ensure that those who are best positioned to guarantee workplace safety take the greatest care to do so. Not builders who build large buildings or casinos in cities and don't care about their workers and only care about greed and profit. The facts arising from recent scaffold law-related litigation demonstrates the prevalence of elevation-related injuries, particularly in New York City, and the continuing need for the scaffold law. For instance, in June 2017, a construction worker in Brooklyn died after falling from scaffolding. A supervisor blamed the man's fall on a slip, but the fire department of New York requested an inspection after finding a loose scaffold shortly after the accident. That same month, 6 construction workers in Queens received non-life-threatening injuries in a scaffold collapse. In September 2017, 2 workers at 2 separate construction sites in Manhattan died from falls. And in October 2017, 2 workers were seriously injured at a Bronx construction site after falling 20 feet as a result of shoddy scaffolding. As these recent incidents demonstrate, there's ample reason why the New York legislature would want to keep the scaffold law to protect the citizens of New York who get up on these scaffolds and do the work to build all those skyscrapers that we all saw when we were in New York. They're everywhere, and somebody's got to build them and risk their lives. As these recent incidents demonstrate, there's ample reason why the New York legislature want to keep the scaffold law and its strict regime in place despite numerous attempts to weaken that for greed, for money for the developer. Given the particularly large amounts of high-rise building construction that takes place in New York and New York City in particular, it makes sense the legislature would want to respond to particularly heightened local dangers and risks by enacting particularly strict workplace safety mechanisms. Notwithstanding the New York construction industry's well-documented risk of elevation or gravity-related risk, a coalition of property developers, people who can make big campaign contributions, contractors, and tort reform groups support H.R. 3808 on the grounds that the scaffold law increases insurance premiums and infrastructure costs. Yet such assertions are unsupported by any publicly available data that can be scrutinized. H.R. 3808 attempts to impose a one-size-fits-all standard that ignores local conditions. These defects defeats the whole point of having a federal system where states are responsible for much of the health and safety laws to protect workers and others precisely because conditions vary from state to state. New York is where they build big buildings on broad shoulders, and they don't want those people with broad shoulders to fall down on their rears, and we shouldn't allow it. We need to be a safety net. Because H.R. 3808 inappropriately circumvents the New York legislature's determination that an absolute liability regime is the best approach for enforcing the duty of contractors and owners to ensure workplace safety, and because this bill hasn't even had a hearing, not even a hearing, I strongly oppose this bill and urge the committee to reject it, go back to regular order, have hearings, have facts established, and then vote on what is the best thing for state-federal relations and for workers. I yield back the balance of my time.
For what purpose does the gentleman from Rhode Island seek recognition?